Hi, I'm Phillip Cha. I'm a mediator and founder of Cha Mediation Services. I specialize in mediating employment and business disputes. For this segment, I want to talk about what is the right timing for mediation. Before I became a mediator, I was a practicing attorney, and so I'll use the attorney's favorite answer to every question, which is, it depends. And that's because it really does depend on the situation, and each option comes with its pros and cons. One option is to mediate pre-litigation, before any lawsuit's been filed. Another option is to mediate relatively early in the litigation, before the parties have invested significant time and money litigating and doing their trial prep. And a third option is to mediate well into the case, maybe even on the eve of trial, after the parties have invested in the case. The right timing for mediation really comes down to the motives of the parties in the dispute. For example, a high-profile defendant like an entertainer, an actor, or a publicly traded company may have an incentive to mediate even before litigation to avoid the negative publicity that comes once that case is filed and the TMZs of the world get a hold of it. Another example is a plaintiff going through financial hardship might have a motivation to mediate much sooner rather than later in hopes of collecting on a settlement, getting paid, and moving on. Either way, if the goal is to maximize your odds of settling the case at the mediation, the parties should wait until they have enough information to be able to evaluate their case and to engage in meaningful settlement discussions. Now, that doesn't necessarily mean waiting until the last minute after you've spent time and money on trial prep. You can actually do it much sooner, like after the parties have exchanged an initial round of key documents and after depositions of just a few of the most important witnesses. In the pre-litigation scenario, where the parties haven't done any formal discovery, there is a greater likelihood of surprise information coming out at the mediation. One way to address this surprise issue is to agree to an informal exchange of information prior to the mediation. In the context of an employment case, this could be turning over the personnel file, some pay records, and the company handbook. Ultimately, because surprise information, like a witness declaration or a key email that wasn't produced, is likely to derail and undermine your settlement discussions, it's really in everybody's best interest to cooperate and produce things ahead of time, especially if we're talking about things that you'll have to produce in discovery anyway. Lastly, there may be a key legal issue like a jurisdictional argument or a preemption issue that can turn the entire case before you even get to the merits. And obviously, the court's ruling on these issues can have a drastic impact on the settlement value of the case. In these situations, it may make sense for the parties to tee those issues up for the court and have the appropriate motions on file before the mediation. Now, you can have your hearing date sometime shortly following the mediation, but having everything ready to go on file in advance really allows the parties to more fully evaluate the strengths and weaknesses of their position and assess the resources and costs of going forward and factor those things into the negotiations. And this really comes back to having sufficient information going into the mediation to avoid surprises and to maximize your odds of settling the case. Thank you for tuning in. If you like this video, please subscribe to my YouTube channel. You can also check out my website at www.chamediation.com. You can also check me out on social media. Links to my Facebook, Twitter, and LinkedIn accounts are in the description box below. And in the meantime, stay tuned for more content. See you soon.